Okay. Mr. Wensloff, do you know, I'm just looking at my Zoom waiting room here. I don't see anybody, the Bordens. Do you know if anybody is representing them? I don't see any appearance on their behalf or their company's behalf.
Yeah, I don't know of anyone representing them in this case. No one's filed anything or contacted me.
Okay, thank you. Ms. Schaefer, I brought you in. Which case are you signing in under?
Drafts versus drafts.
Drafts, okay. I'm going to call that case next, so I'm just going to put you on hold for just a moment, okay?
Okay, thank you.
Thank you. Okay, so let's go on the record in Northland Area Federal Credit Union versus Gordon and Vision Lines Trucking. This is file number 2419755. We have Mr. Wensloff here on behalf of plaintiffs. I don't see anyone on behalf of the defendants, including the defendants themselves, signed in. This is set for a status conference today. Mr. Wensloff, can you kind of tell me where things are at and how you'd like to proceed in terms of scheduling here?
Sure, Your Honor. And this, to some extent, we had some change of personnel. This file got kind of didn't get brought back to my attention until fairly recently. I know that they had expressed an interest in resolving this matter, settling, and I had a little bit of discussion with my client about it. And then, like I said, the file kind of got lost in my office and just recently brought back to me. I think the parties are still on, can still probably settle it. I just need to reach back out to the Bordens and talk to them about it. I believe I have their contact info. I think they gave me their phone number at one point, but that's where we are. I mean, obviously they're not here today. I was kind of hoping they would be so we could potentially talk about that, but that is what it is. So
okay, all right, so this matter was filed last July. So how about I'm gonna give it 90 more days, and then we're gonna have to, you're gonna need to file motions or something's gonna need to happen on it.
No, Your Honor, I apologize. Like I said, we just threw some inner office stuff, but now that it's back in my attention, I'll be reaching out to them right away and hopefully get something either settled or file a motion, within obviously the 90 days, but probably even less.
Okay. I will put that into a pretrial order. I'll send out a notice of the date and time of that next status conference. If it does settle, obviously, if you can file the closing paperwork, and then the court will take that status conference down.
Perfect.
Okay, thank you. That's all, and you're free to disconnect.
Thank you very much, Honor.
Okay, we'll go on the record in drafts versus drafts, and this is file number 2419738. And if I can have counsel put your appearances on, starting with plaintiff.
Good afternoon, Your Honor. Philip A. Greenblatt, my bar number is 54170 on behalf of the plaintiff, Donna Dreffs.
Good afternoon, Your Honor. Jennifer Schaefer on behalf of the defendant, Kenneth Dreffs. My P number is 49438.
Okay, and Ms. Schaefer, when were you retained?
Well, I was actually retained a couple of months ago. The reason this case has been on your docket for a period of time is I'll take responsibility for that. And I told Mr. Greenblatt I would say this on the record. He has the patience of a saint. I have had some personal matters that caused me to not be able to respond immediately. And in the interim, Mr. Greenblatt and I did exchange, memoranda and legal opinions as to what we thought the case was about and whether we should go forward. And so we're now at the point of we both firmly believe our legal opinions are correct on this case, and we should have them heard by the court. And so my intent, actually got an appearance that I was going to file with the court today. Had difficulty doing that, reaching your assistant clerk, but that's my issue. And so I was going to file an appearance and leave it to the court as to whether we should file a full answer and response, or if we may be able to simply do a motion for summary. To my understanding, this is a strictly, I guess, a legal issue of whether or not the plaintiff has any claim whatsoever to the property that she's attempting to claim. And I think the motion for summary disposition would lay out all of those, both factual and legal aspects. And of course, I understand Mr. Greenblatt has expressed an interest in, of course, if he could, an opportunity to amend the complaint. I understand that could be allowed. But I think rather than necessarily filing an answer to a complaint that I think has over 100 plus factual allegations, many of which are extraordinarily in depth and detailed, and in my humble opinion, irrelevant. But rather than doing that, just filing the motion for summary and kind of teeing it up for the court to be able to take a look at it to see if there really is any claim whatsoever. And with that, I of course leave it to Mr. Greenblatt to respond.
May I, Your Honor?
Yeah, please.
All right, so as a courtesy, we've extended a number of extensions. I mean, the answer was supposed to be filed back in August, and then it was supposed to be filed by December 6th. What's important for the court to understand here, and a reading of the complaint lays it out quite clearly, that my client is a vulnerable adult. We've given not only statutory basis for that, but we have affidavits by a medical doctor and a licensed medical social worker. There's factual questions to this, and that's why I suggested to sister counsel that she file a complaint, because ordinarily a court would allow a party an opportunity to amend the complaint unless it's so clearly unattainable that there's no factual development that would preclude summary disposition. And in this case, my client was overreached, and it's undeniable by a reading of the complaint and the affidavits in support of that. Her husband, who was also not a well person, could have simply quitclaimed his interest in the property to her. Instead, the brother-in-law, the defendant, basically overreached at a time where my client had attempted to commit suicide and was under medical care and was pronounced disabled by the Social Security Administration. And there's a list of medical conditions which makes it clear that she was not of the right mind to make a legal decision on her own without legal counsel, which she never had that opportunity. So because money and paper and interest and property, as we all know, is freely assignable, that's what allows the economy to move. That could have been an alternative than to simply waiving a dower interest at the time. It didn't have to remain a dower interest. Her husband could have simply assigned his interest in the property, and she would have been able to share it with her brother-in-law. So I think motion is inappropriate. I think what is appropriate, given the length of time that the defendant has had in this case, is to file an answer. Let me see their answer. I could have an opportunity within whatever time frame the court deems fit, an opportunity to amend it. So it's clear to the court that my client's claim is not lodged solely on the issue of dower, which we all know no longer exists, but based on the fact that she was overreached as a vulnerable adult.
Okay,
So
so
I would ask that the court, lay out a scheduling order, give defendant an opportunity to answer, which should have been done by now, us an opportunity to file an amended complaint if what is listed in her answer makes it clear that an amendment is necessary, and then proceed with either a pretrial or discovery or whatever the court deems an appropriate path forward to an ultimate resolution in this case.
okay. All right. So you're not, at this point, you're not requesting to amend. You want to see what their position is in writing.
Yeah, I think they should have to file an answer to the complaint. I mean, they've had
Yeah.
like
No,
5
no,
months.
I'm not saying that. I'm just, if you were asking already to amend your complaint, it wouldn't make sense to have them file an answer and then you're gonna amend it and they just gotta refile another answer. But if your request to amend the complaint is gonna be dependent on what it says in their answer, then that's a different story. So that's all.
Well, I know, I understand that their position is going to be based on the elimination of dower. And if that is their sole defense, then I could file an amended complaint that makes it clear that that is not the singular basis upon which my client's claim is lodged. So if the court has a preference that we file an amended complaint first, I can do that too. I would just, like a reasonable opportunity to do so, but I'm going to defer to the court's discretion. I just think it's inappropriate, given the amount of time and opportunity to plead or otherwise defend, that they now, at this moment, seek to file a motion for summary disposition.
Your Honor, if I may?
Yeah.
I would actually, I think it would be more expedient for Mr. Greenblatt to actually prepare an amended complaint if he has any other claim, because I will say that our answer, if I were to file it to the 100 plus things, would literally be, we have no knowledge and or these are entirely irrelevant. We don't dispute that the plaintiff in this case may have been some vulnerable adult. She may have had issues. Her husband is the one who would have had any opportunity or ability to do something about that in regard to this property. The defendant that they're suing is her husband's brother, and suggesting that the brother had some obligation to her, should have done something different, had that she had dower rights that she can now claim against the brother. And I think Mr. Greenblatt is acknowledging, and I appreciate it, that very likely there are no dower rights, not only because of the statutory change, but because of the language of the deeds themselves, which was between the mom to the two brothers as tenants in common with rights of survivorship, and then between the brothers themselves was again a joint tenancy with rights of survivorship. And I think the law is crystal clear on that dower just does not attach in that sort of situation. So again, we can go through all the rigmarole of, again, the answer for every one of those allegations is going to be, we don't know, not our issue, irrelevant. Yes, she had problems. We acknowledge all of that. But what it comes down to is this legal issue of, against her brother-in-law, she has no claim whatsoever. She had no dower, whether it was by statute or by the deeds themselves. So to perhaps be more expedient, I guess, again, move this case along, as we all want, it really might help greatly if Mr. Greenblatt did file an amended complaint that better laid out. If there's some other justification or cause of action that I'm not aware of that would help him make a claim, then perhaps we should do that.
Okay, so again, I'll defer to the court's discretion in terms of the sequence of events. But a reading of the complaint makes it clear that as a vulnerable adult who didn't have the assistance of legal counsel, there were other methods for her to secure her interests before just simply extinguishing them at the request of a brother-in-law. So with that said, I'll defer to the court's discretion.
So, Mr. Greenblatt, how much time would you want to file an amended complaint?
Well, so the question becomes the affidavits by the LMSW, the clinical social worker, her doctor that's been treating her back to her disabling condition back to 2008 through the current, whether I'm simply attaching the existing affidavits that say that they've read and agree with the complaint and the allegations, or whether I'm going to have them prepare new affidavits that they still agree with it and with the amended complaint, or whether the court would be sufficient with me just attaching the prior affidavits. But I would think 21 days.
Yeah,
And
I don't think.
part of that is because of my scheduling. I just have a series of complicated cases between now and in the next few weeks.
All right, so I don't think you need to refile affidavits. I mean, I think we're just looking at an amended complaint, a notice pleading that's going to give the defendant adequate opportunity to understand what your claims are and defend against them. So, and I don't want to put you under the gun, Mr. Greenblatt. I mean, if you want 60 days, I'll give 60 days. But if you want, I mean.
Yeah, I mean, yes, I'd take it with the understanding that I'm going to try to do it sooner because I have a client that would like me to move the case along. But I also I don't want to rush into something that doesn't adequately represent their position or explain their position. So I appreciate the courtesy of the court.
Okay, so.
And I have no objection any time he needs for it. That's fine.
All right. So I'm going to put in the pretrial order for now. Plaintiff to have 60 days to amend the complaint. Ms. Schaefer, you need to file your appearance within the next 14 days.
Yep.
And I want everybody to be clear that once that amended complaint is filed, the time limits under the court rules are going to begin running. And if there aren't timely answers filed, then upon request, the court will enter defaults. But I don't want this to languish more than it already has. So Ms. Schaefer, regardless of what's going on, answers are going to need to be filed in a timely manner to the amended complaint.
Yes, Your Honor, I understand. Thank you.
And then once we have the pleadings set, the court will then set this for another status conference.
And will the court extend its current courtesy of allowing us to appear by Zoom for that hearing?
Absolutely, yeah. Yeah, all my civil cases, unless we get to the point where we're having some type of evidentiary hearing, but status conferences, motion practice, it's all by Zoom.
Very good. Thank you, Judge.
Thank you very much, Your Honor.
All right, thank you. That's all for today. The court will send out that order reflecting what we've discussed, and we'll go from there. You're both free to disconnect. Thank you.
Thank you, Judge.
You.
Okay, counsel, just 1 minute. We've got one more connecting in, I believe. All right, Mr. Mirza, are you connecting on the core energy matter?
No, Your Honor, I'm here for a status conference in Moore Equipment Finance, B. Stuckman.
Possible that one got moved. I'm not seeing that on my docket for today.
Okay. Yeah, Mr. Stuckman's in bankruptcy, but yeah, the court set this a few months ago just for a status, but he's still in bankruptcy. The case is moving forward, it looks like. So at this point, there's really nothing here for us at this time.
All right, can you, do you have my, my assistant, Jennifer, do you have her number?
If you could give it to me, that'd be great.
Yeah, it's 989-731-0224.
Okay.
And that's Jennifer. And can you just, after you disconnect, can you just give her a quick call? I just want to make sure that we understand why this isn't on the docket for today. If you're
Absolutely. I'll give her a call right now, Judge.
great, thank you.
Thank you.
Okay, so Mr. Quick and Mr. McCarthy, do we have anybody else connecting on this case?
Good afternoon, Your Honor. I believe my client, Bob Manis, who is with Core Energy, is on the call or on the Zoom as well.
Yeah, okay, we have him. All right. Okay, so let's go on the record in Core Energy versus DCP, case number 1918001. We have both counsel connected, Mr. McCarthy and Mr. Quick by Zoom. This is set for a status conference today. Mr. McCarthy, can you tell me where things are at with this file today?
Yes, good afternoon, Your Honor. I can report to the court when we were last before you, I think we advised that Core Energy had entered into an agreement with Riverside to sell the compression facility, and the closing date was December 31, 2024. I can report to the court that that closing occurred as scheduled and that my client, Core Energy, no longer owns the compression facility, which is an important development. We have shared with Mr. Quick pertinent portions of the purchase agreement, and Mr. Quick and I have had some discussion about the resolution of this case. And I think it's a fair statement to say that our thinking is this, that hopefully we will be able to reach agreement on the terms of a settlement agreement or a document between DCP and Core that will bring closure to this, and that we can present to Your Honor within a short period of time a stipulation in order for dismissal with prejudice and without cost that will close this case.
All right, thank you. Mr. Quick?
Good afternoon, Your Honor. Daniel Quick. I enjoy Mr. McCarthy, his optimism, and I hope that what he says is correct. It's neither here nor there in part, but we did make efforts over the last 8 months since we were in front of you before to try to resolve this case in light of what was represented as a binding purchase agreement, but we didn't make any headway. That deal closed on January 1, and in the last 72 hours, I've been provided access to that agreement, which I was previously denied by Core, and had some substantive conversations with Mr. McCarthy about resolution. It does appear, based on those conversations, that the parties could and should be able to reach resolution at this point. No settlement agreement has yet been circulated, but assuming the court is willing, and I recognize the age on this case, if we could put a control date in for a few weeks out and let the parties see if we can get terms agreed to on a settlement agreement, and then either submit an order of dismissal to the court or come back before you and explain where we are.
Okay, Mr. McCarthy, any objection to that?
No, Your Honor, I think that makes sense. I believe this is a case that we should try to impose as little as possible on the court's time from this point forward. And if we can reach agreement on the terms of a document between the parties and get back to the court with an order dismissing the case, I think that would be ideal. So we are going to need a little bit of time to work on that, and leave it to the court's discretion and your own calendar about what makes sense.
All right, I think given what the parties have provided here to the court today, given that that sale has just occurred, which is a significant development, I'd like to set this out 60 days for a status conference, just knowing to the extent the parties are able to reach a settlement. It takes time to circulate agreements, to agree on particular language. I'd rather build in a little bit of extra time for that rather than having the parties come back in 30 days and say, we've got it settled, we're just trying to work out the language. So we'll set this for a control date at 60 days. The court will send out notice of the date and time of that. If the parties are able to settle and agree on final wording for settlement documents, and those are filed prior to that date, the court will sign those, we'll close the case, and the court will take that date down. If not, that gives us a relatively soon date to discuss where things are at, how to go forward. So I'll put that into an order. I'll send that out to the parties along with the date and time of that next conference. And that's all I have. Mr. McCarthy, anything further on behalf of plaintiffs?
Nothing further, Your Honor. Thank you.
Mr. Quick?
Nothing further. Thank you, Your Honor.
Okay, thank you. Both parties are free to disconnect at this time.
Thank you.
Thank you.
Okay, we've got both sides connected. We'll go on the record in Sheridan versus Sheridan. This is case number 2419880. If I could have both counsel put your appearances on, starting with plaintiff. Ms. Robinson, did you say? I couldn't hear.
I did not say anything. I'm sorry. I was making sure my volume was up.
Yep. Can you put your appearance on, please?
Yes, sir. Brooke Robinson appearing on behalf of the plaintiff, Doug Sheridan.
Good afternoon, Judge Elliot Blumberg on behalf of Kathy Sheridan, the defendant.
All right, thank you. This is an initial pretrial conference in this case. Ms. Robinson, from plaintiff's side, can you tell me where things stand and what you would like to request for scheduling going forward to get this matter resolved?
Yes, Your Honor. I believe we have an offer ready to present to defendant, but I understand that there may be some contention there. So I believe what we need to do is get ordered to mediation and hope that we can conclude this prior to having to actually go to mediation.
All right. Is there a particular period of time that you'd like to have for any kind of discovery prior to mediation?
If Mr. Bloomberg doesn't mind, I think we can handle 60 days of discovery. We should be okay there.
All right, Mr. Bloomberg.
Judge, the plaintiff hasn't even filed their verified domestic relations financial statement yet. So to talk about discovery and mediation would be a bit premature. Under the court rules, the plaintiff has the obligation to file theirs, and then we respond by filing ours. I don't want to go to mediation without knowing what all the assets are. We know that there's a home that needs to be appraised. We've already retained the services of an appraiser. We would hope that the parties could agree to split the cost of that. But I have certainly no problem. I think 90 days is probably a more appropriate period for discovery in this matter. We are not opposed to going to mediation once we know what the assets are.
Okay. All right. So the court will set this for discovery to remain open for 90 days. The parties to complete mediation within 120 days. Ms. Robinson, is this something that's going to need an attorney facilitator, or do you think that community mediation would be sufficient? For some reason, your microphone's not coming through well.
Can you hear me?
Yeah,
There we go. Okay. I believe community mediation should be sufficient, Your Honor.
Mr. Blumberg?
Well, my only concern are there's some, I think, legal issues regarding separate property that I think an attorney mediator would be more sensitive to and would be more appropriate. I don't know, again, the financial situation of the plaintiff. Certainly my client is not in a position to hire an attorney mediator at this point, but I guess we can certainly try community mediation.
Okay, so I'm going to refer it to community mediation, that to occur again within 120 days. And then the court will set this for a status conference at that 120-day mark. And we'll see where we're at that point. Obviously, if it's been able to settle, then we can use that date to take proofs and finalize the divorce. If not, we can discuss how to go forward. Ms. Robinson, any other dates that I can address for your side today?
No, Your Honor.
Mr. Blumberg?
No, Judge. I would just ask counsel if she could send us that form, then we'll be in a position to start talking.
Okay. All right, thank you. I'll put those dates into an order. I'll send that out to the parties along with the status conference date and time. Both sides are free to disconnect at this time.
Thank you.
Okay, if I could have both of you unmute, please. Thank you. All right. Ma'am, you're Mindy Moliterno, is that correct?
Yes.
And sir, you're David?
Yes, Your Honor.
Okay, we're on the record now in Moliterno versus Moliterno, case number 2419875. The record should reflect that both parties are present today by Zoom video. This is set for a status conference or pretrial conference in this case today. I am in receipt of proposed judgment of divorce. Ms. Moliterno, did you want to move forward with finalizing the divorce today?
Yes, please.
All right, and Ms. Moliterno, from your standpoint, are there any matters relating to the division of any assets or debts that need to be decided by the court, or have you and Mr. Moliterno agreed on all of that?
Everything's been agreed upon.
Okay, and Mr. Moliterno, do you agree with that?
Yes, I do.
Okay. All right, so and Mr. Moliterno, did you want to go forward with finalizing the divorce today?
Yes.
Okay, so I'm going to place both of you under oath. Once I do that, I'm going to be asking you each a series of questions. Questions that I'm going to be asking each of you are those that I'm required to ask to establish the grounds for divorce under Michigan law. So if I could have you both raise your right hand, please. You both solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You can lower your hands. Ms. Moliterno, as the plaintiff, I'm going to be asking you some questions first. You filed a complaint for divorce in this case and you signed that complaint. Is that true?
Yes.
And at the time that you signed that complaint, had you been a resident of the state of Michigan for at least 180 days?
Yes.
Had you been a resident of Otsego County for at least 10 days?
Yes.
In that complaint, there's a statement that indicates that there's been a breakdown of the marriage relationship such that the objects of matrimony have been destroyed and there remained no reasonable likelihood that the marriage could be preserved. Was that true when you signed the complaint?
Yes.
Does that remain true today?
Yes.
Are there any children under the age of 18 that were born to you or adopted by you during the marriage?
No.
Are you currently pregnant?
I am not.
Under the judgment of divorce, you would not be receiving any alimony or spousal support. You understand that you would be waiving that forever and that you would not be able to come back later and ask the court for that.
I do understand.
Okay. And do you agree that you've already divided up any personal property and that's between yourself and Mr. Moliterno?
Yes.
And in terms of the division of any real property, that's provided for in this addendum. And that provides that Mr. Moliterno, let's see. This indicates that the property on Berry Creek in Petoskey is going to be awarded to Mr. Moliterno. Is that correct?
It is.
Okay. Are you on the deed to that property?
I am not.
Okay. Are you indebted by virtue of a mortgage or in any other financial instrument to that property?
No, I am not.
Okay. Is there any other real property that's owned jointly by the two of you?
There is not.
Okay. All right. Thank you. Mr. Moliterno, have you heard all the questions that I've asked Ms. Moliterno?
I have.
Have you heard all of her answers?
I did.
Do you have any reason to believe that any of the answers that she gave were untrue?
I do not.
Under the judgment of divorce, you also would not be receiving any alimony or spousal support. You understand that you would be waiving that forever, and that you would not be able to come back later and ask the court for that.
Yes, I understand that.
And do you agree that you and Ms. Moliterno have already divided up any personal property or debts between the two of you?
Yes, I agree with that.
Okay. The court finds that the statutory grounds for divorce have been met by the testimony of the plaintiff and the defendant. The court will grant the divorce. I've signed the judgment of divorce. Ms. Moliterno, you're asking to have your name changed. Is that correct?
Yes.
Okay. So from today forward, because the divorce is final as of today's date, your name is legally changed. So you'll need to call the clerk's office and request a copy of the judgment because you'll need that to change your identification and other documents, okay?
Okay.
Ms. Moliterno, do you have any questions at all?
I do not.
Mr. Moliterno, do you have any questions?
I do not.
Okay, thank you. That concludes this hearing and you're both free to disconnect at this time.
Thank you.
Thank you.
Hi,
Ma'am, can you tell me your name, please?
Renee Rapley.
Okay. All right, we're on the record in Vanderkirchhoff versus Rapley. This is file number 2419803. The record should reflect that Ms. Rapley is connected by Zoom video. Oh, okay, Mr. Vanderkirchhoff is connecting as well.
Cool.
All right, Mr. Vanderkirchhoff, are you able to hear me okay?
Yes, I am.
Okay, so we have both parties connected now. This is set for a status conference today. The last time we met was back in November. The court referred the parties to community mediation and then set this for a hearing today. Mr. Vanderkirchhoff, as a plaintiff in this case, were you able to reach any agreements through the mediation process?
Just an agreement upon the Honda, and that was it.
Okay, are there other matters that are still need to be decided?
We have another vehicle that I was okay with just giving up, but she would like me to pay half of the debt on that vehicle.
Okay. Is there any other issues that remain besides the vehicle?
Not that I'm aware of, no.
Okay. Ms. Rapley, what's your view on that?
That we got married, and as a married couple, we decided to take on this vehicle and the payments and help each other out. And then he had an affair and left. So it's like, you're leaving me with the bill now? Really?
All right. How much is left owing on the vehicle?
Like 20 grand.
Okay. When was it purchased?
It was purchased of May, the end of May, beginning of June
Of what year?
this year, Your Honor.
Okay.
And
All
then
right.
he had like a month later, or a couple months later, and
All right. Do you have any idea how much that vehicle is worth?
yeah, it's worth like $25,000. That's how much the loan is for it.
Okay. Well, what the loan is and what the vehicle's worth might not be the same thing. So I'm just wondering if you know how much it's actually worth if you were to try and sell it, what you could sell it for.
Well, it's a 2021 Volkswagen. So I don't.
Okay. All right.
I don't know
So
how much the loan is for it.
okay. All right. So your position is that that you should sell it and that you should each be responsible for half the debt. What do you want to see happen with that car?
You know, I don't want to see anything happen with that car. I'll pay it. I'll be the woman here because I am. So, Your Honor, I'll pay it. Never mind. Forget it. He can have the Honda that's scheduled for 2 days from now at Secretary of State. We're all set. Just want to be
Okay.
divorced.
All right. Are there any other matters, Ms. Rapley, any other items of property that need to be divided between the two of you?
No, Your Honor.
Okay. All right. So the court will set this for a final hearing to finalize the divorce. Mr. Vanderkirchhoff, there's a document that you're going to have to submit to the court prior to that hearing. It's called the judgment of divorce. That's a form. You can find that form in the same places where you got the forms to file for divorce. So you'll need to fill out that form and submit that to the court prior to the final hearing. And then the court will finalize the divorce on that date. The court will send you both a notice of the date and time for that hearing. That'll be by video, just like we're doing here today. Mr. Vanderkirchhoff, do you have any questions about what you need to do?
Nope.
Okay.
Thank you, Your Honor.
Mr. Rapley, do you have any questions at all?
No, Your Honor. Just
Okay.
want to be slam the hammer and divorce us. Finally.
Okay.
Please.
All right. Okay, well, we'll make that happen at the next hearing. Both parties are free to disconnect at this time. Thank you.
Awesome. Thanks.
Good afternoon.
Hello.
Hi.
How are you, David?
I'm fine. How are you?
Good. Nice and cold up here today.
Okay, looks like we have all counsel connected, so we'll go on the record. This is Raymond versus Johnson and Prather, case number 2319394. We have Mr. Raymond here on his own behalf. On behalf of the Johnstons, we have Mr. Couch, and then on behalf of the Prathers, we have Mr. Carey. We also, although not participating in the Zoom courtroom, we have Mr. Majestic, who's representing the insurance company of the Prathers. He's joining in just for observation purposes. So today we have a number of different matters up for hearing. We have a status conference. We have a motion for summary disposition on the part of the Johnstons. And then we have a motion for stay on behalf of the Prathers. I guess jumping into the most substantive matter first is Mr. Couch, your motion for summary disposition. I did have a chance to review your brief. I had a chance to go through all the exhibits that were attached to the brief, along with the video of the rainwater event that was taped. So I watched that. Mr. Raymond, I did review your brief as well as all the exhibits attached to that. So Mr. Couch, anything that you want to present today by way of oral argument in support of your motion?
If I may, very briefly, Your Honor. I know the court has reviewed everything and is well prepared. I'd just like to make a very short record. As the court knows, this case arises out of a water intrusion incident that occurred back in August of 2021. Mr. Riemann alleges that it was caused by the actions of the Johnstons. Discovery has closed. The plaintiff, in response to our discovery requests, did not disclose any experts, has not provided any expert reports. I'm not aware of any experts who will testify at trial on behalf of the plaintiff. This is not a case that can be resolved without the use of expert testimony. It's simply not something that the jury would otherwise be able to resolve without the consultation of experts. And the plaintiff has no admissible evidence, no expert testimony that the actions of the Johnstons altered the topography adjacent to Little Bear Lake. As the court knows from reviewing Exhibit J to my client's motion for summary disposition, Brent DeRose, the defense expert engineer from Naderveld, concluded after examining the area that the plaintiff's cottage is at the lowest of low points in that area. 60,000 square feet of property drain toward it, just the natural runoff of water. The plaintiff also alleges that the Johnston sump pump is polluting Little Bear Lake. We retained another expert, Tom Clement from Mergent, who took water samples right next to my client's sump pump, out in the middle of the lake, different areas of the lake, had them analyzed. There's no evidence that the effluent from my client's sump pump is in any way polluting the lake. The plaintiff has made that allegation, but he doesn't have an expert to support that at the time of trial, or more importantly, in response to our C-10 motion for summary disposition, come forward and argue to Your Honor that they have admissible evidence to create a question of fact that has to be resolved by a jury at the time of trial. And lastly, Your Honor, my client's motion for summary disposition argued a statute of limitations defense. As the court knows, claims for trespass and nuisance and negligence must be brought within 3 years. Mr. Riemann is very clear. He's alleging that the Johnstons, conducted this or caused this to occur in June of 2020. His case was not filed until August 11th of 2023. Once again, Your Honor, in response to a C-10 motion, the plaintiff has to come forward with admissible evidence to create an issue of fact without expert testimony, without admissible evidence at the time of trial. And I keep saying the word admissible, Your Honor, and that's because the plaintiff is representing himself. He can't question himself on the stand. I'm not sure if he intends to hire an attorney to have somebody question him if this case goes to trial. I'm not quite sure how that's going to work yet, but the plaintiff has no experts and cannot support these allegations that they have made against my client. So for those reasons, we would ask that the court grant summary disposition and dismiss the claims against the Johnston defendants.
All right, thank you. Mr. Raymond, your response? You're muted, Mr. Raymond.
Better?
There we go. Yes.
I'm not sure it'll be better, but at least you can hear me. Your Honor, Mr. Couch didn't spend a lot of time on his issue of the witnesses. I think we covered that pretty well in the brief. Mr. Couch's argument seemed to me as though he did not receive or read my brief. We did attach extensive evidence regarding the support for our claim that the Johnstons changed the topography, as well as the fact that the topography caused the flooding of my house. Counsel, the insurance defense attorneys appeared in the case after some things had been done, and perhaps they didn't get the memo because the initial disclosures of the Johnstons, I'm going to show just to make sure you know what I'm talking about. This is the Johnstons' initial disclosures, and this is page 2, where it talks about the factual support for the claim, and then it goes on to admit, I guess you'd say acknowledge, but I think the legal term is admit, that there was a stone channel made up of large stones on the edge of the Johnston property designed to control.
Mr. Raymond,
Yes.
if it's a record, you can just refer to it, but I can't see what you're holding. You know, it doesn't come through on the camera.
Okay, I'm sorry. So I'll read it to the court. It is page 3. I know these don't get filed, but if there's any contest, then certainly submit it to the court. It says that there is no ditch between the properties, but rather a collection of larger rocks to allow the flow of water to the lake and slow erosion. These sit on defendants' property and have never been filled with any material. So the Johnstons acknowledge that the ditch that plaintiff claims existed did exist and that they never filled it. Yet, Mr. Couch has submitted a photograph to the court to show the current condition, and it clearly shows that there is no stone channel or ditch or what have you. And the only allegation in this case is that the Johnstons filled it. The court read my affidavits. Mr. Kobliska, the attorney who lived there from 2004 back from 1991, testified that, and I'm at paragraph 5 of his affidavit, which is attached to my brief, during my ownership of 6762, which is the Riemann property, there was never a single time when surface water from rain or any other source caused water to run toward or into the residence. So that covers 1991 to 2004, Your Honor. Then, as the affidavit of Mr. Kobliska makes clear, paragraphs 11 and 12, he then moved into the Johnston property at 6772. And at that time, he paid for Larry Culver of Larry's Excavating in Atlanta to build the ditch because he was making a change to the topography and to ensure that the historic flow of water remained at the border of the properties and did not cause any flow towards the homes. He put in a ditch. Mr. Culver, I attached Mr. Culver's estimate for the repairs to that ditch, and he calls it a ditch. Mr. Kobliska also says in paragraph 12 of his affidavit, which is attached to my brief, that there was never a time in the 12 years that he owned the Johnston property from 2004 to 2018, it's actually about 14 years, there was never a time where water flowed to either property, either home, and the ditch worked perfectly. The Johnstons have now admitted, and they've submitted receipts showing that they had delivered 20 yards, which is 2 dump trucks full of topsoil in the first week of June 2000, just as alleged. Just to address the statute of limitations claim, Your Honor, the damage to plaintiff's home, to my home, didn't occur as a result of the delivery of the 20 yards and the building of the berm and the covering of the ditch in 2000, in June of 2000. All that did was create additional flow and problems for Mr. Johnston. Then in approximately June of 2021, Mr. Johnston had to deal with all the sand that was running off down the road because of the changes he made into his catch basin. And so at that time, he changed plaintiff's driveway. And that's what caused the problem in, June of 2021. And as the court can see from Ms. Van Sumeren's affidavit, she not only watched Mr. Johnston do this, she watched and saw as the next rain caused the flooding, which didn't go into plaintiff's home, but when they left and returned a month later, that's when the flooding was found. So we have absolute direct correlation to the witness testimony about the existence of the ditch, the covering of the ditch, and the flooding. Mr. Couch wants to point to his experts' reports. The expert reports only show that plaintiff's property floods, that the current condition of plaintiff's property is susceptible to flooding. That supports plaintiff's claim. The question of this case, Your Honor, is, did plaintiff's house flood previously? And if not, why? What caused the change? And the experts hired by Mr. Couch never address that. They don't argue it. They don't claim to know what happened. And Your Honor, Mr. Couch has said that there's other issues in the case, and there certainly are, that require expert testimony. And he points to the claim that the Johnstons dumping water into the lake from under their home, which is drained from their sewer field, is causing problems at the lake. But Judge, they do not contest that they built an improper bubbler system out into the lake. And I have, despite what Mr. Couch has stated, I have listed experts on that issue. The expert interrogatories, number 15 and 16, are my two.
Yeah, again, Mr. Riemann,
Yes.
when you hold that up, it muffles your voice, so I can't hear your voice and I can't read it. So
Okay, so I'm just pointing to paragraphs 15 and 16 of plaintiff's response to the expert interrogatories. And there I've listed Patricia Osborne, who is the soil erosion officer for the Otsego Conservation District, and Bill Oming, who is the EGLE Resource Program Compliance Coordinator in Gaylord, to testify as to the improper placement of that bubbler and the improper dumping of water directly into the lake. It violates the statutes that are alleged in my complaint, and those witnesses will testify to that. Your Honor, as to my need or reliance on experts, I have listed, as I documented in my reply to this motion for summary disposition, multiple experts which will prove causation in this case. Now, it's not necessary, Your Honor. I have eyewitness testimony, multiple witnesses that I've attached to my brief. Certainly Ms. Van Sumer and Mr. Scully, Mr. Lyon, Mr. Kobliska, all the affidavits were attached and directly attribute plaintiff's flooding for the very first time ever on this property, according to the witnesses, to Mr. Johnston's activity of first building a berm, raising up his property by topsoil, covering up the ditch, and then ultimately, which really caused plaintiff's problem, is the covering or the change of his driveway. And Your Honor, Mr. Kobliska is a very respected attorney. He drafted his own affidavit, and he noted to the court in there that he had been warned in 1991 when he purchased the property, don't make any change up by the road. don't change the driveway, don't change anything, because as legend has it, he doesn't really know who or when or where. And I heard the same story. Somebody tried to change it one time and the Riemann property flooded the very next time. And so it was returned to its natural position, and it's existed for the 27 years before the Johnstons purchased it then, and nobody's seen any flooding. So it is susceptible. The historic flow does protect both properties. The Johnstons changed it and plaintiff's property flooded. Here's a picture of, Your Honor, the bubbler system, in case there is any question of whether it existed. This is defense attorney Mario Lehman's husband, Brett, removing the bubbler system within a few weeks after plaintiff served the complaint. That's him removing the system. They have the Johnstons have denied that occurred. They said that Mr. Lehman did not remove that. I've stated in my brief that I don't believe there's any question of whether plaintiff's property actually flooded. And I'm sorry, before I jump to that, I want to stay on the experts. Judge, in my response to the expert interrogatories, I listed that I had not yet secured experts, but that I would supplement that. And then I listed the areas of expertise, including excavators, real estate valuation, property damage experts. And then I attached to my brief in response to motion for summary disposition my supplements, which included Mr. Dwan of Midwest Adjusting. He's an expert in damages. Mr. Couch has stated that I have never presented him with a report, which is true. And he and I have corresponded for probably 8 months since the date that he promised, if I let him and his experts come into my home in May of 2024, he would forthwith present me with his experts' damage report. He has not done that. And I've told him, we have a lot of email open exchanges going back and forth saying, look, I can't imagine there's a big dispute about what the damages are. So I'm going to accept yours. And I proposed, if there is a dispute and we cannot resolve it by appointing an adjuster between us, then I'll have my expert conclude and finish his report. I gave the initial analysis during the facilitation, the entire presentation. The judge, you saw the witness affidavits, which have stated that Mr. Riemann and Mr. Johnston had an argument, an oral, words. The day the Johnstons came up, that Riemann, the plaintiff, found the flooding, and that there was yelling and screaming that Mr. Johnston made the change because sand from the road was flowing down after he made the change to the property into his dry well. Judge, here is a picture of what plaintiff found when he arrived August 12th. That's the sand. Instead of going into Mr. Johnston's dry well, now the sand went right directly into Mr. Riemann's house. And as the court saw from the affidavits of Ms. Van Sumeren and Mr. Riemann, if the court gives that any credence, Mr. Johnston had previously stated he made the change to the driveway because after he created the berm and added the topsoil and filled in the ditch, sand was coming down. And that he tipped the driveway into the center because he believed that the water could be absorbed and not flow into plaintiff's home. But instead, the sand clearly flowed into plaintiff's home. Judge, I just want to give you a feel for the defendants are claiming.
Okay, again, Mr. Riemann, I can't hear you when you lean away like that.
Okay, thank you. I'm going to show a picture of August 13th, the day the flood was found, just to show all the condition of Riemann's home and all the property that was being removed and thrown out. Again, the defendants have all these pictures that included suede leather furniture that got wet because things had touched the ground and then soaked up into the leather. One piece of the furniture was salvaged. The mattresses, most of plaintiff's property was gone. I'm going to show the court another picture of the walls, which show the entire home had been flooded at about 4 to 6 inches. This is the damage to the walls. This is a picture of the furniture, the cherry furniture the plaintiff had recently brought into there, which is at the same, you'll see at the same approximate level of 4 to 6 inches.
So Mr. Reno, I mean, I don't want to cut you off here, but the motion is really, in my view, challenging the causation element here, not damages. So
okay,
whether or not there was damage to your property, the defendants aren't arguing that there wasn't damage. They're arguing that whatever their clients did or didn't do didn't cause that. So
right. Thank you, Your Honor. The issue then is, did the Johnstons make changes, and did plaintiff's property flood before or after the changes? So I want to show, we haven't had pictures, I understand, Your Honor, of the ditch, the stone channel, what have you. It's because it's in a back area of the property where you just don't photograph very much. And the pictures I'm about to show actually were taken out on the water from plaintiff's dock, showing guests catching fish. And I've been able to narrow it to take a long view to actually catch a photograph of the stone channel. It isn't very good, but this is what we have, Judge. And I'm gonna, so it's just to the right of the second tree that's in the photograph. And it's, again, it's not very good, but you can see down there that there are bigger stones that are no longer there. And if we just had the picture, I'd understand the court saying, oh, I'm not sure. But if you look at the affidavits, especially of Mr. Kobliska, and then the estimate of the expert Larry Culver, you'll see they're talk about the stone ditch or channel. Judge, compare that to
when was that picture you just showed me taken?
This was I have that somewhere, Judge. 2018 to 2019.
Okay.
So
why did you not submit that as an exhibit with your response to the motion?
Judge, I have hundreds of pictures. So I thought that this would be best to handle it this way. We do have a picture attached.
And as you know, under the court rules, when a motion is made and supported by documentary evidence, then you have to respond with evidence showing that there's a question of fact, and holding it up in front of the camera, I can't see it. I mean, that's
okay. Well, Your Honor,
in my view, those are all things that should have been submitted as part of your response to create a question of fact here, and with dates of when those pictures were taken, so that I have some kind of reference of what they mean in relation to your claims.
Well, Judge, they're being offered as demonstrative exhibits that show the court the substance of what is discussed in my case. That channel was discussed in the affidavits that supported plaintiff's argument. And the plaintiff also said that he observed and had photos of the subsequent covering up of those things. Again, Judge, I've got hundreds of photographs as to what is relevant. I did inquire of the court's assistant as to whether or not we could have an in-person hearing so that we could handle those issues easier, and I could document them better, but this is what we have.
You could have
so
just submitted ones you thought were relevant with your brief, and then I could have looked at them.
Well, so I apologize if I was not helpful to the court as much as I could have been, and
I want to, I need to consider your case, but you have to give me the information so that I can review it. And I mean, we all know what the court rules are, and it has to be submitted with the brief.
Well, Judge, there's plenty of evidence that I submitted with the brief to support that the stone channel existed and then doesn't exist now. Mr. Couch himself showed pictures of the court showing that the stone channel is not there presently. So the question is, what happened to it? I do have, again, for demonstrative purposes, these are photographs that I've provided to Mr. Couch and Mr. Carey. And this is the day in question. And I don't know if the court can see it or can remember to compare to the previous picture, but it shows the dirt covered over the stone ditch and the entire property of the Johnsons, and also shows a pile of dirt that was delivered that day, which is right here, Judge. There's a dirt pile, and you can see that the entire area is covered over with dirt. The ditch is gone. Again, I would rely on what I did attach to my brief and support it. And these are just to show, I did explain to the court in my brief and the affidavits in support of my brief, talk about wildflowers and vegetation that existed, and that there was no burn present when Mr. Johnston purchased the property. And this next photograph will show it in full. This was not a suburban grassed over lot. This was a lot full of wildflowers and brush and terrain, which the expert, Mr. Culver, my excavator from Larry's Excavating in Atlanta, will testify, as I proffered in my brief, that he designed this to prevent water runoff to either property, the Johnsons or Remans. But I would like the court to look at the area behind the biker, who's my daughter, in 2016, 2.5 years before this property was purchased by the Johnstons. And you'll see the prolific growth of brush and wildflowers, which was part of the water runoff design. Compare that, Your Honor, to the current situation, which I'm going to show you in the next photograph and is consistent with all the attached photographs to both Mr. Couch's and my brief. And that shows that's all gone. And that photograph also shows, Your Honor, something that never occurred before that, and that is that there's a berm that prevents the water from flowing into the Johnston property, and there's an accumulation of water that flows down the hill from Johnston to Reman. Your Honor, the next photograph is going to show snow collected in the ditch and then a berm going down plaintiff's driveway, leading away from plaintiff's home towards the dry well or runoff channel on the Johnston property. And I'll talk about it after I remove it. The snow can be seen accumulated in the ditch or channel. And then there was a little, surface water erosion of that area, but it led over to the Johnston property, just as described to Mr. Kobliska. Counsel has said in his brief that a picture is worth 1,000 words, and that's true. I'm going to show you a picture presented by Mr. Couch's experts, which show the current water flow, which is down plaintiff's driveway and to the right or directly at plaintiff's house, just as plaintiff alleged and as supported by his affidavits. Your Honor, there's no way that the change could occur from going in one direction to the exact opposite direction without human intervention. And we have direct eyewitness testimony from Ms. Van Sumeren, who said she watched Mr. Johnston do it, and then she heard him explain and admit why he did it. And then she saw him apologize after and purchase remnants for plaintiff to use as a result of the flood damage that he caused the very next day after the flood and after the argument with plaintiff. To the extent we've discussed in the brief, and Mr. Couch has shown a video or suggested, I don't know if he's going to show it yet or if he sounds like the court's already seen it, water flowing down plaintiff's driveway. I'm going to show a picture of the flow down into the middle of plaintiff's driveway and then flowing in an additional path to plaintiff's driveway. This I've submitted to council. This was in 2022 in October. And this is a very common occurrence. This is how the water flows now when it rains. And then this picture, Your Honor, is right before it enters plaintiff's home. This is coming off the ledge. You'll be able to see, hopefully, the rapids that flow off that and accumulate right in front of plaintiff's house. On these occasions, when I'm there, I've been able to dig trenches to divert the water out of the home. The problem is when I'm not there. I showed the picture of with a berm with the water collected in front of it, Your Honor. I want to show the court another picture that I've shared with counsel from 2016, again, approximately 2 years, showing after the wildflowers had been cut in the fall so that it's relatively flat, the court can see where there's a young man on a motorbike and his motorcycle is exactly where the current berm is. And he has his foot on the ground showing that it's flat. That area is now completely elevated, as I showed in the photograph with the berm and the water. This is the prior condition before Johnston made the changes. The last thing I'll speak to, Your Honor, with regard to causation is this counsel has not at all explained why experts are needed. This is not a situation where it requires a formula, like in the case I presented in my brief, to calculate where a ship could have been at a certain pace and time out in the ocean. This is like watching the defendants lift a crane with a stone over plaintiff's home and dropping it. We don't have to have an expert to explain gravity. That's commonly known. The court, I think, in a previous hearing, commented that it agreed with plaintiff that water flows downhill. We can watch it. We both agree. The current condition of plaintiff's property is susceptible to flooding. What we don't agree on is whether it flooded before and whether the Johnstons made changes causing it to flood. Plaintiff has supported that. And in further support of it, plaintiff listed, and I attached the supplements to plaintiff's expert disclosures to my brief, two excavation experts, Larry Culver of Larry's Excavating. He will testify, as his estimate indicates, that he built the ditch. He designed the entire 2004 development water flow situation of the now Johnston property, and that his ditch worked perfectly. And all it would take is building the ditch back, and he could return the property, both properties, to adequate, safe water flow. I don't know if I attached it, but I'm sure I explained to the court that I did ask Mr. Couch to agree that I could have Mr. Culver repair the ditch so that I could then repair my home and use it, because currently it just floods. I can't do anything with it. And Mr. Couch denied that request. And, I just don't want to make any changes to the current situation that then will be attributed to me. So Mr. Culver will testify, and also the owner, Mike, and I can't think of his last name right now, might be Marsh, but Mike from Earthworks is the owner operator of Earthworks in Gaylord, and he has extensive experience.
Mr. Reedy, I've given you a lot of latitude here. You've been going for almost a half an hour, and we're 35 minutes in. I only had a half an hour set aside for this hearing. I have hearings that are now backing up.
I understand. Thank you.
The purpose of oral argument is to supplement your written submissions. So I'm going to ask you to wrap it up so that Mr. Couch has an opportunity to respond and I can roll. And we still have a motion from Mr. Carey that we have to address. So I think I've given you more than reasonable time to explain your position. So please wrap it up now.
Yes, Your Honor, and unless the court has any further, if the court has any questions on any specific issue that you don't think I've covered, I would appreciate, or I thank you for your patience.
Okay, thank you. Mr. Couch, anything you want to say in response?
Very briefly, Your Honor, the defendants object to the plaintiff attempting to create a question of fact by presenting the court with pictures and representations of what Mr. Riemann claims individuals will testify to at trial. As the court correctly noted, a C-10 motion says that today is the day. He has to come forward with admissible evidence to create a question of fact. He acknowledged that the issue here is whether changes were made. This is a case that involves an allegation of altered topography. The defendants have an expert engineer, Brent DeRose, and I'm quoting right from his report, Your Honor, the changes made by the Johnstons have not resulted in additional stormwater flows onto the Riemann property, end quote. Tom Clement, our water expert from Mergent, I'm quoting, the sump pump outfall pipe does not negatively impact the water chemistry of Little Bear Lake. Mr. Riemann does not have experts to support his case. He does not have experts to counter the defense experts. And for that reason, this case does not need to go forward to trial. So we would ask that the court grant summary disposition on every claim. And if the court is not inclined to do so, at a minimum, grant partial summary disposition and at least carve off this allegation that my client's sump pump is polluting the lake, because the water samples are very, very clear that there's no additional pollution. Thank you, Your Honor.
Okay, thank you. So again, I did very thoroughly go through all the submissions by the parties prior to the hearing today. The defendant's motion was brought under a number of different portions of 2.116. In my view, the statute of limitations argument doesn't apply. I agree with Mr. Riemann that the claims here relate to matters that took place within the applicable statute of limitations. So I don't find that that's a basis to dismiss any of the claims. Although nobody's touched on it here as part of oral argument, I also don't find any potential foreclosure issues to be dispositive here. So the court doesn't find that to be a matter that would justify dismissal. So really what we're looking at, and what I looked at this under, was a C-10, whether or not, when looked at in the light most favorable to the non-moving party, in this case plaintiff, whether or not sufficient evidence has been brought forward to create a question of fact as to the issues raised by the defendant in their motion. I think both sides accurately set forth the standard under C-10, and I've referred to it here. Again, the court has to view all the evidence in the light most favorable to the non-moving party. The court has to find that no reasonable jury could find that there is a question of material fact as to one or more of the claims. So looking at plaintiff's claims against the Johnstons in particular, there are 3 counts. Count 1 alleges negligence and negligence per se. And I'm not referring to the numbers in the complaint itself, but just in the complaint as they're listed as counts. So, and then count 2 is the nuisance in fact, nuisance per se. Count 3 is trespass. And the defendants are asking for summary disposition of all of those claims. Looking at the negligence claim at count 1, specifically paragraphs 40 and 41 of the plaintiff's complaint, alleges that there were changes made by the defendants Johnson that prevents the dissipation of surface water, and changes by the defendant Johnsons that have caused additional water to go onto the plaintiff's property. And I really view this, and I think the parties have kind of acknowledged this as well, as we're really dealing with is a causation issue here as part of this motion. In other words, did any of the activity that the Johnstons did or didn't do on their property or on plaintiff's property cause the flooding that resulted allegedly in damages to the plaintiff's property? In support of their motion, the defendants cited to the Netterveld report, which has been alluded to here today. I did review that report. The conclusion of that report was that any changes that were made did not cause additional flows onto the plaintiff's property, and that there isn't any extra runoff from the defendant's property onto the plaintiff's property. Their conclusion is that any water problems that the plaintiff is experiencing are related either to natural conditions and or problems with plaintiff's property and not things caused by the defendant. As I indicated, once the defendant has brought forth documentary or other evidence to support a finding that there is no question of fact as to causation, then it's incumbent upon the plaintiff and the court will to bring forth documentary or other evidence indicating that there is a question of fact on that issue. While the plaintiff has listed experts, the plaintiff did not provide any affidavits or deposition testimony of any experts or any people in the field of excavation, anyone other than just lay affidavits, which I will address in a second, but no testimony in the nature of a scientific report as that prepared by Netterbell to show or to provide an opinion that anything that the Johnstons did or didn't do has resulted in the extra water flow that caused the damage. What plaintiff did submit are a number of affidavits, an affidavit from Lyon, and that affidavit doesn't provide any kind of opinion, and none of them really do. They state what they observed before and what they may have observed after, but none of the affidavits provide even a lay opinion that what the Johnstons did or didn't do actually caused the problem. The affidavit of Mr. Kabliska specifically states that he has no expertise in drainage or surface flow issues. And while he certainly describes conditions that existed and changes that he made, he doesn't even Mr. Kabliska does not provide an opinion that anything that the Johnstons did or didn't do is the cause of the issue. Same thing with Ms. Van Sumeren and Mr. Scully. They're basically describing conditions before and after, but none of them is providing any kind of opinion, even a lay opinion again, that what the Johnstons did actually caused it. So in my view, the plaintiff has failed to bring forth any evidence that would contradict the expert's report and opinion on causation. There isn't anyone who can testify on plaintiff's behalf that the actions of the Johnstons caused the flooding, other than just a lay opinion maybe of what they think happened, which any of us could go out there and look at it and say, well, I think this is what happened or this is what caused it. But there's really no probative value to that. The best the plaintiff really can show is that in the experience of those people, it didn't happen previously. And even that's not conclusive because just because it didn't happen before doesn't mean it couldn't happen again based on different weather conditions. And properties naturally change over time, even if they aren't intentionally altered. And I also viewed the video. I think that supports defendant's argument here. That video doesn't depict any of the water at any point going anywhere near the defendant's Johnston's property. It starts in the road and it goes directly onto plaintiff's property. So it doesn't appear to the court from viewing that video that there is any water coming from the Johnston property onto plaintiff's property. For those reasons, the court finds that the plaintiff has failed to create a question of fact in light of the report prepared by the defendants that pretty conclusively states that the defendant Johnston did not cause the conditions on the plaintiff's property. As to the claims for nuisance per se, that's pled in the complaint as a violation of the Natural Resource Protection Act. Again, there are some allegations and conclusory statements in the complaint. Those haven't been supported by any kind of documentary or deposition evidence by the plaintiff. And so the court finds that the claims under count 1, subsection A regarding negligence should be dismissed again under C10. As to sub B under count 1, that relates to the fence. The defendants didn't make any kind of arguments with regard to that part of the complaint. So the court is not ruling on the fence issue that's pled as part B, sub B of count 1. As to count C, or I'm sorry, as to count 1, sub C, that's the drain and bubbler system. Again, in support of the defendant's motion, they provided a report, an expert report and opinion that the defendant's discharge of water from their sump pump is not causing any issues with the lake. The defendants also provided an email from individual Lowe from Eggle, and that opinion indicates that a permit would not be necessary for the Johnsons to do what they did. Plaintiff did not produce any kind of documentary or testimonial evidence at all to contest the evidence provided by the defendant. So as to sub C, the court finds that the defendant's entitled to summary disposition in that issue. Looking at count 2, the negligent, or I'm sorry, the nuisance claims, the nuisance, in fact, an element of nuisance, in fact, is that the defendant created or caused the nuisance. The court finds that that fails for the same reason that the negligence claim failed on the issue of causation, and the court adopts its findings with regard to the nuisance, in fact, claim. With regard to the nuisance per se claim, there hasn't been any evidence provided by the plaintiff indicating that there's been no documentation or other testimonial evidence provided by the plaintiff that anything that the Johnsons did is a violation of any kind of ordinance or other statute. And there's no evidence that what they did is a nuisance at all times or under any circumstances that would be necessary to support a claim for a nuisance per se. So the court finds that the defendants are entitled to summary disposition as to count 2. As to count 3, regarding the trespass, there's a lot of allegations in count 3. A lot of them were not addressed by the defendant's motion. But some of them were, because some of the claims under the trespass count relate to the water runoff and so forth. The court finds that to the extent that the trespass claim is based on the defendants having created a water issue, or the water issues are caused by the actions of the defendant, the court finds that those should be dismissed. However, for the reasons that I stated as to the negligence and causation issue. However, to the extent that the trespass claim relates to intrusions onto the plaintiff's property by the defendants, again, that's not an issue that was addressed by the defendant's motion. So the court finds that to the extent that the trespass claims relate to intrusions onto the plaintiff's property, whether the defendants caused actual damage to the property of the plaintiff, again, unrelated to the water runoff issue, the court finds that again, there hasn't been a motion for summary disposition related to those claims, and so those claims are not dismissed. And again, to the extent that I haven't addressed it, the court finds that arguments related to the statute of limitations, for any kind of foreclosure action, evidence related to the submission of witness or exhibit lists, or I'm sorry, motions related to the witness or exhibit list, none of those would form a basis for summary disposition in this case, other than C10, as I've indicated. So for the record, the defendant's motion for summary disposition as to count 1, Part A is granted pursuant to MSCR 2.116 C10. Part B, the court is not ruling on, so it's not part of the motion. Part C, granted pursuant to C10. As to count 2, again, the court grants the defendant's motion pursuant to C10 as to both nuisance in fact and nuisance per se claims. And then count 3, the court grants motion for summary disposition to the extent that the trespass relates to claims that the defendants caused the water damage, not with regard to actual intrusions or damage caused by those intrusions by the defendant onto the plaintiff's property. And Mr. Couch, if you can prepare an order that reflects that ruling of the court today.
I will, Your Honor. I've been taking very careful notes, and I will do my best to craft an order under the 7-day rule that comports with Your Honor's ruling. So thank you.
All right, thank you. Moving on, Mr. Carey, your motion for stay on behalf of the Prathers, I did have a chance to review that. Is there anything you wanted to present by way of oral arguments?
No, I don't think so. I think I laid out our position. And the court entertained the status conference in the deck action this morning and is aware of its pending nature and the 90-day framework that we placed on hopefully a completion of the deck action. This matter has put a significant strain, if not exhausted, my plaintiff's ability to defend, my client's ability to defend, I'm sorry. And I think both by way of fairly defending the action, potentially resolving the action, knowing whether or not there is coverage and whether or not there is defense cost is critical to my clients. I request the court grant our request accordingly.
Thank you. Mr. Rimmon, do you take any position with regard to the motion for stay?
No, thank you, Your Honor. I do not take a position as to the motion per se. Your Honor, I would note I was not aware that there was a status conference this morning. I am a party to that case, and I would have thought I would have been a party to that. I don't know that it's a very big deal, depending on what occurred, but I did file my answer and appearance, and so I don't know what happened. I would like a copy of the order and maybe a chance to obviously object to anything that occurred, but
the file reflects that you were served with the notice of hearing on November 27th at 6762 Beach Road. That's where the court sent the notice of that hearing to.
Yeah, Judge, I have U.S. Postal Service informed delivery, so I get a picture. I do stay in Florida and Puerto Rico and downstate quite a bit during the winter, but I did not get any informed delivery notice. I will ask somebody to go out and check and see if that failed somehow. But in any event, I don't know what happened. I was not aware of it. I'm not sure if anything important happened. I'd like a chance to object, but I don't take any position as to whether or not the court thinks it's important to wait until the deck action is resolved to proceed with this case.
Okay, and for the record, again, the court did send notice of the date and time of the hearing today to you at the address that we have on file. It was not returned to the court, so I don't know where it is, but the court complied with its obligation in terms of providing notice. Mr. Carey, the court, since there's no objection, the court will grant your request. And so if you'll present an order reflecting that ruling.
I will. Thank you.
Your Honor, I have a question. Given that the court is staying the claims against the Prathers and not all of Mr. Riemann's claims against my clients were dismissed, and the claims are joined right now in one complaint, does that mean the fence claim or the rope fence claim against my clients, is that also stayed?
No, I mean, I don't see any reason why the claims regarding your clients can't go forward. They're pled separately in the complaint. So I don't see any reason why we would need to hold off on litigating your client's part of it.
And thank you, Your Honor. It's actually my preference that it not be. We would like a resolution of this case. So thank you.
All right. So in terms of the status conference, what I'm going to do, because this was a significant and detailed ruling here today, the court's going to set this for a status conference in 30 days to give counsel and the parties a chance to kind of go through, Mr. Couch, with your clients, how you want to proceed, and Mr. Riemann a chance to determine how you want to proceed.
Thank you.
So the court's going to set this for another status conference in about 30 days. At that point, the court will get input from counsel as to how we want to go forward with the Johnston claims. And I'll send out notice of the date and time of that hearing. Mr. Riemann, if you have another address or an alternate way you want the court to send a notice, then I'll just ask that you notify my office. Is that okay?
Yeah, no, I don't. It's been really good up till this point.
Okay.
I know Jody was replaced as the bail person, so I'll ask the new person if something happened or.
Okay.
Judge, I just have one issue that the court mentioned a video. I'd just like to see if we could dispose of that issue. In Mr. Carey's brief, he indicated that he would be showing the court a video at the hearing. I'm sorry, not Mr. Carey. Thank you. Mr. Couch had indicated in his brief that he'd be showing a video to the court. I subsequently asked Mr. Couch's office and they provided to me the video. I wasn't aware the court had the video. In order to just dispense of it, Your Honor, can we say for the record that the video played no role, or should we address in your decision, or should we address the video?
I think I did address it as part of my ruling. So
then I would just comment on the video, Your Honor. The video shows pretty clearly that.
So Mr. Riemann, we're already a half an hour beyond the time. Again, I gave you the majority of the oral argument time to yourself. Anything that you had to raise should have been raised at that point. So I'm sorry, I've got to move on, and the court's already issued its ruling. So you've had more than adequate opportunity to make a record, both in writing and on the record here today. So this concludes this hearing. All parties are free to disconnect at this time.
Thank you, Your Honor. I'll
Thank you.
still be in order.
Thank you, counsel.
Thank you, Your Honor.
Okay. Counsel, can you tell me how to pronounce your last name, please?
Zlatopolsky, Your Honor.
Zlatopolsky. Okay, Mr. Zlatopolsky, I see your plaintiff in McCog versus Nowak. I don't see any of the listed counsel for defendant. Do you know who you've been dealing with at Think Factor?
Yes, I do, Your Honor. It's the law firm. If you allow me 1 second, I'll grab the file. 1 second, Your Honor.
Yeah, sure.
Your Honor, we're dealing with Brown Kendrick, Attorney Frederick Overdeer. I spoke with him yesterday. Someone is supposed to join from his office.
Yeah, that's what I'm just trying to figure out. I've got a waiting room full of attorneys here, and none of them are the ones I was expecting. Mr. Klomek, you're here on the cruise matter, is that correct?
Yes, Your Honor.
Okay, Ms. McCartney, what matter are you signing in on?
I'm here for McCog versus Nowak.
Okay, great. All right, hold on 1 second. Mr. Klomek, I'm just going to put you back in the waiting room for just a minute.
Very well, thank you.
Okay, we're on the record in McCog versus Nowak, file number 2419893. If I could just have counsel put your appearances on.
Good afternoon, Your Honor. Greg Zlatopolsky, P41-341, appearing for the plaintiff.
Good afternoon, Your Honor. My name is McKenna McCartney, P88061, I am filling in for Fred Overdeer on behalf of the defendant.
All right. This matter is set for a scheduling conference in this case today. Mr. Zlatowski, can you just tell me what you'd like to see for scheduling going forward?
Your Honor, I spoke with brother counsel yesterday. It's my understanding we need to do some discovery, and then we will be mediating this case with attorney Michael Coffey.
Okay, how much time for discovery?
For me, it's not much. I was wondering if the court can give us maybe 120 days. I don't know.
Okay. Ms. McCartney?
We would defer to the court. 120 days works for us. We would prefer 180, but if this court prefers, we can do it in 120.
No objection to 180, Your Honor. Whatever the court feels comfortable with.
Okay. I'm going to set this for 180 days discovery. Is there any reason, it sounds like you've already selected a mediator, any reason why we couldn't complete the mediation at some point during that discovery period, Mr. Zlatowski?
Your Honor, like I said, we agreed to Mr. Coffey to mediate this case, and I don't see any reason why it should not be resolved.
Okay. Ms. McCartney?
Yes, counsel spoke with Mr. Overdeer regarding mediation. I know they discussed doing that within the midpoint of discovery.
Okay, great. Okay, so the court will set aside 180 days for discovery. I'll order that mediation to occur within that period of time for discovery. Mr. Zlatowski, I just ask that your office just provide in writing the name. I know you've stated it for the record here today, but we put it in the file, and my assistant needs to process so that we know who the mediator is. So if you could just submit the selection in writing to the court. And then what I'll do is set this for a status conference at about that 180-day mark. If the matter was able to be settled through mediation, we can take that date down and the parties can submit closing documents. If it doesn't settle, that'll give us an opportunity to check in and see what we need to do for scheduling going forward from there. Mr. Zlatowski, any other dates that I can address for your side here today?
No, Your Honor.
Ms. McCartney?
Yes, Your Honor. We would propose that any witness list, including expert witness list, be disclosed around midpoint in discovery.
Okay, any objection to that?
No, Your Honor, both of us have submitted 302 disclosures, so that alone should provide enough information at this point.
Yeah, okay. All right. Anything else, Ms. McCartney?
Yes, Your Honor. We would just like to mention that we'll be relying on our right to have plaintiff attend an independent medical evaluation.
Okay.
And then we also just wanted to inform the court that lead attorney Bill Ewald has since retired as of January 1st. So
No
Fred,
objection, Your Honor.
Thank you. Go ahead, Ms. McCartney. No, you're all right.
so Fred Overdeer will be lead counsel on this case.
All right, if Mr. Overdeer can just file, I don't know that we need a substitution of counsel, but just something in writing so that we don't keep referencing Mr. Ewald as lead counsel.
Yes, Your Honor. And Mr. Overdeer apologizes for not being here, but he was in court on another matter at this time.
Okay. Thank you. I'll put this into a written order that'll go out to the parties and along with the date and time of that status conference at about 180 days. Both counsel are free to disconnect at this time. Thank you.
Thank you so much, Your Honor.
Thank you, Your Honor.
All right. Am I pronouncing your name correct? Is it Glomek?
Yes, Your Honor, that's fine.
Okay. Thank you. All right, we're on the record in Cruz versus Cruz, case number 2319351. And Mr. Klomek is here on behalf of defendant Ms. Cruz. Do not see Mr. Blumberg in the waiting room, although we're well past the time. This was set for a hearing on plaintiff's motion regarding the mediation agreement. Have you had any discussions with Mr. Blumberg prior to the hearing today?
Not specifically with, no, Your Honor, I have not. I did, no, I did not, Your Honor.
All right. Very unusual for Mr. Blumberg to not appear for a hearing.
Let me just check with my secretary. She may have spoken directly to him.
Okay. I'm going to check with my assistant too while you're doing that.
Okay, you talked to him directly?
Correct, yes. Him and I corresponded about the date. He signed off on it.
Your Honor, I don't know what happened, but he apparently knew about it. And he consented to the date and time. So I don't know, maybe I don't know if the weather's bad up there or I don't know.
My office is checking with his office right now. So if you could just hold on, I know we're past the time. And I apologize for that.
That's fine. I don't want to stick it to him or anything like that, Your Honor. We'll just.
So just if you both can just hold on for just a minute and I'll bring you back in just a second.
That's fine, Your Honor. Thank you. Well, here we go.
Okay.
Okay.
All right. We'll recall the Cruz versus Cruz matter. We do have Mr. Blumberg joined in now. So we'll go forward on the motion regarding the mediation agreement. Mr. Blumberg, anything that you wanted to state in support of your motion?
Well, Judge, frankly, I did not know the motion was going forward today. I know that there was an adjournment on the last scheduled date of the motion at the request of the new counsel. I hadn't been made aware of when the next hearing was going to be.
Okay. All right, Mr. Klomek, how do you want to proceed today? I don't know.
Well, we did. My understanding is we did do. My staff worked with you. Well, I don't. If he says he's not prepared, I don't. Judge, I don't know if it makes a difference or not in this matter. But I guess what is Mr. Does he want an adjournment or what is he asking for?
Yeah, Mr. Blumberg.
Well, Judge, I was prepared to argue this at the last hearing. I got a frantic phone call from some secretary asking me to stipulate to an adjournment, which I did. So I'm a little bit taken back by counsel's attitude in regard to this matter. He's been in this case now for what, 2 weeks?
I'm not saying it. I'm trying to cooperate. I'm not saying anything. What
All
do you-
right, so I think I have a solution here. Probably nobody's going to be happy, but I think it's a fair solution given the way things have gone. So we did have this set for hearing on December 2nd, which Mr. Blumberg did agree to adjourn. I did sign a stipulation in order on that date of December 2nd, moving it to today's date. And it was signed with your permission, Mr. Blumberg. So I don't know. I'm assuming you got a copy of it, but maybe not. But anyway, that's what's happened. So I think in light of Mr. Blumberg's concession at the December 2nd hearing, it's only fair if he's not ready to go forward today to adjourn it yet again. It's not really what I want to do. I'm sure it's not what council wants to do either, but I think it's fair under the circumstances.
I have no objection if council wishes for an adjournment. I mean, I have no reason to doubt his representations.
Okay.
It just was never on my calendar. I mean, again, I didn't actually even sign the stipulation. I was perhaps less than more than willing, but I was happy to accommodate them at their request. And if it didn't get put on my calendar by my staff, and then I apologize.
Okay, so what I'd like, Mr. Blumberg, as the moving party, if you can renotice this for a hearing on my motion day on the Monday in February.
I will do that, certainly. Thank you.
Okay, great. Thank you. Appreciate everybody's patience. All parties are free to disconnect.
Thank you, Judge.
Okay, Mr. Weiss, are you signing in on the Spartan versus Sitz tax case?
Yes, I am.
Okay.
I'm not sure how I got kicked off somehow. I apologize if it was my fault.
Yeah, it's been a rough day here, so it could have been a technological thing. But we're on the record now. This is file number 2419857, Spartan Sewer and Septic versus Sitz tax. This was set for a pretrial hearing today. You're representing Mr. Weiss, the defendant. Sitz tax. Mr. Ingleson is listed as counsel of record for the plaintiff. He's not joined in. Have you had any discussions with him at all relating to this case?
Yes, I have. We talked initially. We also filed a counterclaim and a third-party complaint as well. And I've asked him to accept service of the third-party complaint. I haven't heard back yet, but we have been able to talk professionally, and I don't believe there's going to be any problem continuing to do so.
Okay, I'm going to go ahead and enter a scheduling order. If Mr. Ingleson wants to object later, we can take that up, but I do want to move forward with it, even though it's not here. Is there anything that you want to request in particular in terms of discovery?
No, I don't think we need that much, but I just need to arrange third-party services, a third-party complaint, so we can get an answer, and I want to see that stuff before I start actually doing some discovery, so I'll know what it is we're fighting about. And I was thinking I would see him on this call. That's why I didn't follow up with him since we last spoke, but obviously that didn't happen.
Yeah. The other thing I can do is I can reset this for 30 days and we can proceed with scheduling at that time.
That's just if you want to issue a scheduling order that gives us 120 or 150 days for discovery or something, that's probably fine. I just don't want it to be 90 or something, because I may be 30 more days before I get something, and then I know I have a huge trial in March rather, that's going to affect my schedule or availability.
Okay. And then is this a case that would benefit from mediation?
I believe it would. I think that's far superior to any kind of case evaluation. I would certainly be in favor of mediating within the next 60 days if you want to, I want the answer. I need something to know what we're fighting about, but otherwise I do think it would make sense to sit down sooner rather than later with somebody.
Okay. Have you worked with Mr. Engelson before? Do you think you'll be able to agree on a mediator?
Yes, I believe we'll be able to agree, but no, I have not worked with him beforehand, but my contact with him during this case has been nothing professional, and I have no reason to believe that it will stop.
Okay. All right. Okay, so what I'll do is I'll set this for a period of 120 days for discovery. I typically just order that mediation occur within the time for discovery. So whenever you and Mr. Engelson are able to get that scheduled, I will ask that you confer with him and agree on a mediator, notify the court of your selection in writing within the next 14 days.
That's fine.
Or notify the court if you're unable to agree. I will put all this into an order. Then the court will set this for a status conference at about 120 days. And we'll see where things are at. If it looks like you guys are moving in the settlement direction, we can schedule in that direction. If it looks like we're moving in the trial direction, we can schedule that way. Any other dates that I can address for you today?
No, other than is it, if it turns out that the two of us file a stipulated order to extend discovery, is that something you'd consider, or is that something we'd need to do by motion?
No, typically a first request, I will, we can do that by stipulated order.
Okay. Just checking. I wasn't sure of your practices, Your Honor, so I apologize.
Sure, no problem. Okay, I will, like I said, get those dates out to both of you in an order. Also, I'll send out the notice of the date and time of that next status conference, and you're free to disconnect at this time.
Thank you for your time, Your Honor.
Thank you. All right, Ms. Cock, are you able to hear me okay? If you can both unmute, please.
Yeah, I can hear you fine.
Okay. Ms. Cock, are you able to hear me all right?
Yes.
Okay, great. We're on the record now in Cock versus Mackey. This is file number 2419771. I do have a proposed judgment of divorce here, and Ms. Cock, did you want to go forward with that today?
Yes, please.
Okay, Mr. Mackey, do you have any objections to that?
No, I don't.
Okay, so I'm going to ask both of you to raise your right hands. I'm going to place you both under oath. So if you can do that, please. Do you both solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Yes.
Thank you. You can both lower your hands. I'm going to be asking you each some questions. The questions that I'm going to be asking are those that I'm required to ask to establish the grounds for divorce under Michigan law. Ms. Cock, as the party filing for divorce, you signed a complaint for divorce and you filled that out. Is that correct?
Yes.
Correct.
I'm sorry, Mr. Mackey. These questions are for Ms. Cock first.
Oh, sorry.
No, you're okay. Ms. Cock, at the time that you filed the complaint, had you been a resident of the state of Michigan for at least 180 days?
Yes.
Had you been a resident of Otsego County for at least 10 days?
Yes.
In the complaint for divorce, there's a statement that indicates that there's been a breakdown of the marriage relationship such that the objects of matrimony have been destroyed and there remained no reasonable likelihood that the marriage could be preserved. Was that true when you filed that complaint?
Yes.
Does that remain true today?
Yes.
Are there any children under the age of 18 that were born to or adopted by you during the marriage?
No.
Are you currently pregnant?
No.
Under this judgment of divorce, you would not be receiving any alimony or spousal support. You understand that you would be waiving that forever and that you would not be able to come back later and ask the court for that.
correct.
Have you and Mr. Mackey divided up all the personal property and any debts between the two of you?
Yes.
And do you own any real estate or real property together?
No.
Mr. Mackey, have you heard all the questions that I asked Ms. Cock?
Yes.
Have you heard all of her answers?
Yes.
Do you have any reason to believe that any of the answers she gave were untrue?
No.
Under this divorce, you also would not be receiving any alimony or spousal support. You understand that you would be waiving that forever and that you would not be able to come back later and ask the court for that.
Yes.
And do you agree that the two of you have divided up all the assets and debts of the marriage?
Yes.
Thank you. The court finds that the statutory grounds for divorce have been met by the testimony of both parties. The court will grant the divorce. I've signed that judgment, so the divorce is final as of today. If either of you would like a copy of that judgment for your records, you can obtain that here at the clerk's office in Otsego County. Ms. Cock, did you have any questions at all?
No, sir.
Mr. Mackey, did you have any questions?
No, sir.
Okay, thank you. That's all for today. You're both free to disconnect at this time.
Thank you.
Thank you.
Okay, if you folks could unmute, please. All right, and just for the record, sir, you're Jeff Fervella, is that correct?
Yes, sir.
All right, and ma'am, you're Campbell Fervella, is that correct?
Yes.
Okay. All right, this is set here today for a hearing, I believe, to modify a personal protection order. And you're both requesting the same modification, is that correct?
Yes. Yes.
Oh, all right, and what you're requesting is that it be modified to allow Avery to send mail or other communications, but not, I just want to make sure that I'm clear. You're talking about written communications, is that correct?
Correct.
Correct.
All right, and is it limited just to written?
Yes.
Yes. Written,
Okay.
email, or letter.
Okay, so electronic communications are okay?
Yes.
Yes.
And what about text? Those are sort of written, but not really. I just want to make sure that I craft the order so it has the restrictions that you want in it still.
Yes. Text, letter, or email.
Text, letter, or email. Okay. And no other communications though.
Correct.
All right, so the court will grant the motion as to both orders in this case. I will issue an updated order as to each case that reflects the change. It will spell out very specifically what we've discussed here today. And the contact will be limited to what the two of you have stated here on the record. And if you would like to get copies of that order, I probably won't get it done today, but it'll be ready by tomorrow. So you can call or stop in at the clerk's office if you want that for your records, okay?
Okay.
All right. Thank you, Judge.
Thank you, Your Honor.
Do either of you have any questions at all?
Nope.
Okay. All right, thank you. That's all for today, and you're both free to disconnect at this time.
Thank you.
Back to the Herfella matter, I do want to make a record as to each case. This is 2319546 and 2319545. Both of those, the petitioners appeared, the respondent did not appear for either hearing and did not contest the request for modification. Okay. Looks like we have both counsel connected, so we'll go on the record in Parker versus Fowle. This is case number 2419835. If I could have counsel put your appearances on, starting with plaintiff, please.
Rick Houghton, Michigan Auto Law, on behalf of the plaintiff.
Paul Slough on behalf of the defendants, Mary Fable.
All right, thank you. We're on the record here today for a pretrial scheduling conference to set some dates for going forward. Mr. Houghton, can you just tell me a little bit about the claims in this case and what you would like to see for scheduling going forward?
It's a standard motor vehicle crash, Your Honor. Regular pain and suffering. There is no medical. There should be no economics, honestly. I gotta make sure with that when I look through the initial disclosure a little bit closer on my review, but I'm pretty positive there's no excess economics. As far as scheduling goes, I think a standard scheduling order would be in order. I don't see any real weird things happening here. Mr. Slow and I haven't talked yet, but I don't believe liability to be an issue. He may disagree, and I'll let him speak to that.
All right, thank you, Mr. Slough.
Yeah, I don't think liability is going to be challenged. I mean, we'll see what happens in discovery, but I'm not aware of any facts that would lead us to challenge liability at this point. The only other issue we should probably discuss, Mr. Fable is actually deceased. And we did prepare our initial disclosures, so we'll be sending those over, Mr. Houghton, and we'll have a copy of the title in there. Probably more to the point, he wasn't an owner on the vehicle anyway at the time of the accident. So we should probably talk about dismissing Mr. Fable. But otherwise, everything counsel indicated is accurate. I would think maybe 5 months and then see where we're at.
Okay. Any objection to the time frame, Mr. Houghton?
No, I just have to dig into the decedent issue. That's the first I'd heard of it. So we'll have to get our complaint amended here in the not so distant future. But obviously, if we're going to dismiss him, we can talk about that.
And we could just do a dismissal without prejudice. I mean, I can prepare that if that's easier than an amended complaint.
I'm looking really quickly here, and I'm sorry, I'm a little ignorant in the moment. That's the husband of the driver, correct?
Correct.
Okay, so he's just an owner. Yeah, we can.
Oh, no, he wasn't even an owner on the vehicle.
Oh,
So
he was not.
Copy the title too. Yeah, he was not an owner, and he was already deceased on the date of the accident.
Perfect. It'll be pretty easy to clean up, Your Honor.
All right, so I'll just ask that gets addressed within the next 30 days. I'll put that into the pretrial order. And
absolutely.
We'll set aside 5 months for discovery. Any objection to mediation, facilitated mediation within the time frame for discovery?
We do it between discovery. I kind of like to do it after discovery closes. Paul, what do you think?
I'm fine with that.
All right, so say 180 days for mediation.
Yeah,
sure.
that'd be great.
All right. Mr. Houghton, any other dates that I'll set what I typically do, Mr. Houghton, is I don't set a lot of real specific dates in the initial pretrial conference. I set a period for discovery, cutoff for mediation. And then I set a status conference for the close of discovery and see where things are at that point, if it hasn't mediated, settled. Are there any other dates that you would like to include?
No, I think it's pretty straightforward. I honestly, if liability is not being disputed, I mean, we'll probably name an accident recon simply in case Paul changes his mind at some point, but we won't need one. I don't think we'll have any experts. I see this being a 2 to 3 day trial, more likely than not, maybe 4 at the most.
Mr. Slough, any other dates that you want to set today?
No, I don't think so. Thank you.
All right, I'll put all the dates we've discussed into an order, get that out to the both of you along with notice of the date and time for that status conference at about 180 days. And you're both free to disconnect. Thank you.
Thank you. I appreciate it. Have a great day.
Yeah, thank you.
Okay, let's see. Mr. DeLuca, you're appearing on behalf of plaintiff in this case, is that correct?
Yes, Your Honor.
All right, sir, are you Robert Edwards?
Yes, Your Honor.
Okay, is Sarah Edwards with you?
No.
All right, we'll go on the record now. This is Bidwell versus Edwards, case number 2419785. The record should reflect that Mr. DeLuca is present on behalf of the plaintiff. We have Mr. Edwards here. Mr. Edwards, do you have an attorney at this time?
No, I do not.
Okay, Mr. Edwards is here on his own behalf. Ms. Edwards is not present. This is set today as an initial scheduling conference in this case. Mr. DeLuca, on behalf of plaintiff, can you kind of tell me where you're at with this case and what you'd like to see going forward for scheduling?
Yes, Your Honor. I do believe we've reached a settlement in this matter. It's just at this point a matter of finalizing the settlement, reducing it to writing, and then entering the stipulated order of dismissal. Candidly, since nobody filed an answer, I think I can probably just file a notice of dismissal without even having to get anybody else to sign it, a voluntary dismissal with prejudice. I just need a little bit more time to, put pen to paper, so to speak.
Okay. What do you think in terms of timeframe? Is that something that you'd be able to do within the next 30 days?
Oh, definitely within the next 30 days. If the court wants it sooner, I could probably do it sooner. I'm just incredibly busy right now. So any additional, if you can give me 30 days, that's sufficient. I will certainly get it done within 30 days.
Okay. All right. So I'll note for the pretrial order that the parties, well, first of all, Mr. Edwards, do you agree that there's been a resolution of the matter?
Yes, Your Honor.
Okay. All right. So I'll have the pretrial order reflect that the parties have settled. I expect closing documents within the next 30 days. I will set this for a status conference at 60 days just as a control date. If for some reason it hasn't been closed up by then, that gives me a date where I can check in with the parties to see what the holdup is. If we get the closing documents before that, the court will simply just take that date off the calendar. So,
sounds good. Like I said, Your Honor, I think I'm probably just going to be submitting a dismissal, voluntary dismissal.
All right, very good. Mr. DeLuca, anything else I can address for your side today?
No, Your Honor.
Mr. Edwards, do you have any questions at all?
No, Your Honor.
All right, thank you. That's all for this hearing, and both parties are free to disconnect at this time.
Thank you, Judge. Take care.
Also concludes the court's afternoon.